thinking that, maybe we might be able to somehow incorporate, that if the officer has had 2 or 3 complaints, maybe the person in charge of the job improvement plan may be able to override. Yes, the officer can go to mediation, or no, we're now going to the termination process of, this officer, or whatever the case may be. Does that make any sense?
So if I hear you correctly, you're talking to the decision maker question? Or more the type of
More the
complaint?
inclusion, exclusion.
Okay.
I don't think anything should be excluded from mediation other than litigation and violence. And if you're seeking litigation, if you want something from the court to make a decision, then you obviously are not a candidate for mediation.
The JPIP program that you mentioned is, well, and I appreciate that, how you're linking that. In this particular case, that particular program is probably not going to be a criteria you want to use for that. That has more to do with an internal issue of evaluating the officer's ability to perform a particular task, whether it's turning in reports on time or other issues related to job performance. It has nothing to do with interacting with the public.
Oh, okay,
So
okay.
it's completely an internal evaluation system
Gotcha.
for determining whether or not they're doing the job that they're slated to do, as opposed to how they interact with the public and whether that's appropriate or not. That particular aspect wouldn't be. The only other comment I'll make on it is that I'm a little concerned about excluding cases based on previous cases, and only because of this. The mediation process is supposed to be something that's beneficial to the officer, but it's mostly beneficial to the civilian making the complaint. That's the whole point of this, is that it's beneficial for everyone. And I don't know that if people who make a complaint against an officer should be denied the opportunity to have it mediated simply because there's a previous one pending, or something else happened, or somebody else decides maybe this is not a good idea because I'm predicting the outcome of what's going to happen before. And that's the only fear I would have for that, is that we have to remember what the initial goal is here, is to give people an opportunity to mediate their complaint, not somebody else's.
Heather?
I was going to say, I feel like we're hearing a lot from everyone that we want to focus on excluding as little as possible because, and I think one thing that we had written here about, if the possible exclusion criteria, a case in the past 12 months or mediation within the past 6 months, what Mr. Glazer is saying and what Mr. Grandboss needs to be saying as well is that to have a specific number and just have that say, oh, if they've had 3 mediations to exclude it, maybe we should be a little bit more flexible with that. And I don't know how to do that, but like we all said, mediation is beneficial for everyone. And like Mr. Furman said, it could have been a good thing that they have had multiple mediations because the officers wants to meet with members of the community. So.
I would just maybe make a suggestion that we table that specific discussion as far as whether previous mediations would would cause an exclusion factor for a later time, because I think that hinges on what these cases are going to look like on an officer's disciplinary file. And that's something which we have yet to decide here at the committee, and also something which I have to report back to the committee one more time from civil service, and I have to speak to the Civil Service Commission first to see what's even plausible on the subject of what a mediated complaint will look like on the file. So in order to bring that from the abstract to the concrete, specifically if I'm an officer and I'm mediating, if I'm having a case being mediated, that afterwards it's not on my record, and then I want to do that 3 or 4 times, that might look different for this committee choosing whether it's an exclusion factor as compared to a disciplinary history that actually shows a mediated case on the file. So it's just my suggestion. People don't have to follow it, but we might want to have that discussion later on after we find out what's possible with Civil Service Commission and what's not.
I would just add that in some jurisdictions, certain types of allegations are considered too serious to be mediated, and those aren't just uses of force. In some places, those are racial slurs, sexual misconduct. I can't think of any
San Francisco was,
San
I think they
Francisco is the
excluded-
only model that excludes those. All the other ones, all the other districts I spoke to actually included them. But is that suggestion okay with you, Captain Glusser, you, Captain Hargrove?
Yes, I think that's appropriate.
Yeah. Okay, I don't mean it to be a suggestion that everybody takes if people don't think it's appropriate.
And I'm just wondering, why does mediation on someone's file have to be a negative? Why can't mediation on someone's file that
It would be a negative.
is a positive
That's a good
in
point.
terms of, it could be a good thing, in which case I want to go to mediation.
Well, there's
It
three,
depends
there's
on
three,
who's looking at the file. And
Right.
whether you see the world half empty, glass half empty or half full. Some folks will look at that and say, I think it's a good thing, and some's gonna say, well, there's smoke, there's fire. So, we don't wanna get bogged down in that right now, but
there's generally three categories we found.
Let's take a
Is
look
the
at it.
one where it's mediated, it shows mediated on the file and it's taken into consideration as far as whether the officer gets a raise or whether they actually can rise to a higher level. Situations where the case says mediated on the disciplinary history and it's not taken into consideration for future disciplinary actions or future elevations in status. And then the third category we found, and it's obviously not exclusive, these were just what we found. The third category was where it's just not mentioned whatsoever on somebody's file at all.
Right, but can't we have, for example, 2 levels where there's a mediation, and this was a good one, and there was a mediation that caused adversarial, it heightened the adversarial situation so that it's not just black and white, that there are different things that happen.
We create the world here, whatever people want to do.
Just one more comment, and I don't want to beat this horse, but one more comment on that. And part of the problem in looking at how many complaints someone has, or whether they're qualified or eligible for mediation, what situation is eligible for mediation, is we sometimes have to look at the particular officer and where they're assigned. For example, you have a traffic officer, he gives out 50 tickets a day. And he does that 5 days a week, 250 tickets a week, 1,000 tickets a month, 12,000 tickets a year. At some point, someone's going to be disappointed in getting a ticket, maybe make a complaint. That should be understood. That's going to happen. Some of those complaints may be legitimate, some of them may not be. The officer who works in property and evidence, accepting property and evidence and giving a receipt, will never get a complaint about traffic violation. Okay? So you have to look at where they're assigned and what they're doing. And you can't say, well, this officer got 4 complaints for a traffic ticket, issuing traffic tickets, so he's not going to be eligible for mediation. Okay? When you consider he's given out 12,000 and he only got 4 complaints. That's not a very bad record necessarily. Okay? Whereas somebody else, it might be a problem. And that's all I'm saying. We're not going to solve that problem right here, right now, but all I'm saying is you just have to be cognizant of the dangers of looking at it too globally and saying, well, if you have X number of complaints, you're going to be ineligible, or we can't allow this to go through because the potential exists for an outcome that would predict advance. That's sometimes something that we have to do in the police department. That's why our input is sometimes necessary, because one officer is not the same as the next officer, the same as the next officer. Depends where they're assigned, what they're doing, and what their responsibilities are to determine whether or not you should anticipate. A very active officer who is in a tactical environment is going to have a different type of exposure to the public than an officer who works in administrative at headquarters on the 5th floor. They're not going to have any exposure to the public. Okay? So you have to look at that and just keep everything in context. And I think that's what the police department's input should be for, is for that context.
So how do we feel, I'm sorry, just one second, how do we feel about tabling the civil service related issues for right now? Is there any objection to tabling these criteria until we have more information?
Civil service is gonna tell us what we can and can't do anyway, right?
Right,
So,
yeah. Okay.
Can I just ask a question though? Officer has chronic or serious misconduct issues. I don't know if that's a civil service question.
I considered it a civil service question because we, okay, you know what, I'm back on that.
what is that one?
It says officer has chronic or serious misconduct issues.
The only thing that I thought was Civil Service Commission, and I could be wrong on this, is they will have the power to decide what actually shows up on a disciplinary history or not. I think that they need to have say in that process.
The only reason I included that is because it seems to me that this question is really about how does the mediation reflect in their history, right? And if the mediation reflects, I can't think, sorry.
Well, I'm getting confused and a little uncomfortable because I think there are two things operating here. One is trying to decide what cases, what kinds of cases and what kinds of people are appropriate for mediation. And then there's another issue that's coming up that what is going to be the impact of these mediated cases and on the people who enter into mediation, specifically the officers. It seems to, I'm uncomfortable thinking that this group is going to decide about the impact. It seems to me that's up to the Civil Service Commission and to the police department and so on. This group, I think, can decide about what's
I mean,
appropriate for
ultimately, we're just
mediation.
making recommendations to the chief of police and Susan, right? And they're the decision
Right.
makers, but that is
And
definitely the
Judge
purview
Johnson.
of
But
what
this
we're doing
group is
here.
talking about, I mean, should be talking about whether we think, having 15 mediations in a year ought to affect the officer's disciplinary record?
With information, but yes, this group is meant to determine how the mediation reflects on that officer's record, what the incentives are for the officer to do mediation.
So in other words, mediation is not being offered as a way to avoid infractions on your record.
That is
It could
one
also
possibility.
be an infraction on your
Right, we haven't made that decision yet.
Because that, to me, I guess that's where it doesn't make sense. It seems to me mediation is supposed to keep you from, in other arenas, mediation keeps you from going into
Right.
court, keeps you from getting suspended from school, keeps you out of the disciplinary system.
Right.
So why are we talking about mediation being part of the disciplinary system?
Well, because different places do it differently, right? And so in some places, if the mediation is considered unsuccessful, there's a negative mark.
Well, then
on
you
the
go
record.
back to the disciplinary system.
Well,
Right.
as he pointed out, we have a time limit, right? So there's a 60-day time limit, right? So you could have an unsuccessful mediation and go back to investigating and then your time is up.
Can that be changed? Like, if someone
If
goes
we
into
went to Baton
mediation,
Rouge
then
and
can the...
change the law, that's.
But I mean, can you stop the clock, with mediation and then go back to it?
That is a police officer's employment rights
That's
issue.
state legislation again, yeah, which
So
has
we're
been very
talking about
difficult to
mediation
change
as a
otherwise.
disciplinary process.
This is part of the disciplinary process, and there's no way to avoid that.
Right,
We're
I mean,
out of that.
we can include, I think, just knowing the police officer's Bill of Rights a little bit, and please correct me if I'm wrong, those at the table that know it better, but it seems to me that mediation can be integrated into the system of discipline and investigation and PIB without changing the police officer's Bill of Rights. However, if we change the timetable, we absolutely would have to change the police officer's Bill of Rights.
It just seems pretty implausible that a police officer, if this is going to become an infraction, encourages people to go to mediation.
Well, it's not that it's gonna be an infraction, right, but it's how it shows up on the file. There are different ways that have different impacts, right? So we're not talking about the mediation being listed as like a violation of a rule, right? But do we say it's closed by mediation? Right, do we just mark that it was mediated and have no reflection of how that was looked at? Do we give them a positive mark for doing the mediation? Like, these are all part of the incentive system that we have to determine, right? And so we have to make a recommendation that will ultimately be decided by the chief, Judge Johnson, and Susan Hudson about how this reflects on the officer because it's part of the incentive system. Now, I don't think any jurisdiction really made this a black mark on the officer's record unless it was an unsuccessful mediation.
So when you're talking about inclusion, then you're talking about, we're trying to talk about getting into mediation is like something we want, it's like gonna have to be a plus for them.
Yes, we definitely need to make it a
So if we exclude
positive.
them, then we have to have, I mean, it's like saying, well, you're not good enough for me.
The only program
That's
which
a
I
real-
found, I'm sorry.
I'm sorry, I was gonna say, say, that's very anti-mediation philosophy to exclude people from mediation on those grounds.
The only program that I found gave any negative marks, if an officer was involved in mediation, was DC, and that was only if the officer was scheduled. DC has an involuntary program where the officer is required to do mediation, and if the officer doesn't show up to mediation, then they had a disciplinary charge as a result.
But I believe it was either Seattle, whoever had the mediation agreement situation. Who was that, Portland, maybe?
There's a bunch of them that have agreements, but I was not told of any programs that actually had a disciplinary process involved if the officer acted
Whoever
inappropriately.
had that agreement though had a consequence if the agreement was not adhered to.
It was probably DC.
Yeah, I don't remember who that
DC's
was.
real stringent.
Yeah.
The confidentiality agreement, the resolution
No, there was
agreement?
some, whoever had a resolution agreement had a,
DC.
yeah. But, okay, so to bring us back on track, I think we've agreed to table the issues regarding the number or types of mediations and complaints the officers had. I'm withdrawing my inclusion of chronic or serious misconduct issues, but do we feel like we can make a decision about the rest of these?
Well, I have a question about the one that says complaint stems directly from an arrest.
Yes.
I didn't see that in the notes, but it might have, I might have missed it in that other cities. That was an exclusionary criteria for other models. Was it, or like, sort of where did that come from? That like, what it says to me is that if you are arrested, that mediation can't occur for that person, with that officer.
What, that's specifically if the complaint is false arrest.
False arrest.
Right.
Gotcha.
Not that I got arrested for a traffic violation and I'm complaining that he cursed at me during my arrest. That's not the same thing.
Can you just specify that?
So what you're saying is if the person is complaining of a false arrest, mediation is not the place for them to address that.
Exactly.
What we said before, something about criminal or civil litigation,
Right. So that would also mean though, if there is an open charge against that person, that complaint could not be mediated while the charge was open.
Which is kind of unfortunate, I guess, because.
I do not want to be subpoenaed by a defense attorney.
Yeah.
Do you know what I'm saying? I don't, Ted.
As we're struggling to make these decisions, I'm thinking, kind of going back to why we're doing this, and if a person has a complaint against them, and we don't have any mediation, that complaint goes through whatever processes it's been going through, and officer either gets punished or doesn't get punished. The public either felt it was fairly treated or unfairly treated because they were cops, monitoring cops, and they always give them the breaks, whatever. So for that officer, he's going to get a bad mark if he keeps having complaints and they do, something to warn you about somebody doing bad stuff without mediation. So there's a bad thing will happen to the officer when they start getting a lot of complaints, even if they're sustained in a certain kind of way. They start to be looked at kind
That's
of
the
funny.
state, right?
On the other hand, if we have mediation, it's still a complaint. It's still something that might be monitored, that someone got so many complaints. But the choice of mediation, as opposed to the other, creates another opportunity to mend things with the community, but also to mend things with the cop. What I'm getting at, if I'm doing my job and I have other cops giving me feedback that I'm doing a good job because I'm a tough cop, so you can't tell me I'm wrong for this, plus I'll be sustained in any investigation because I didn't really break any laws. On the other hand, if that officer went through mediation, even an officer who is in these categories that we have here, too many complaints, serious misconduct, all of those things, even that officer, if they went through a process of mediation in which some aspect of empathy is created when one stands in the shoes of the other person, and one has to rethink their behavior in light of an experience that they never had, because they're never in that relationship of this kind of the facilitated dialogue, then the possibility of that officer changing and even being able to say to other officers, you know, I was wrong for that, and you're wrong for that too, so let's chill on this and let's do things different, and for the work with people in the community to feel different. Now, how that looks in terms of it's a part of a disciplinary process, if it's a successful mediation, you have successful and unsuccessful. I don't know if there's a way in the department, a way to look at these things and say, if he had 10 successful mediations, he shouldn't, because he should be improving. But I guess I'm trying to say that there needs to be some difference between a mediation that doesn't work and one that does work. And then what was if it didn't work, it had to go back to police investigation, and they sustained that the complaint was justified, then there would be higher negative marks. But I don't know how to distinguish all of those things, but I'm saying mediation should not be a bad thing.
Yeah.
And it should not be on the record as a bad thing. And the positive aspects of mediation are greater than what we're talking about in terms of even these officers that are chronic problems could be changed by that if they ever had that relationship. In the public, who I can't stand that because he's one of the worst officers in our community, there might be something that changes there. I don't know, I'm just throwing that out there.
Okay, how about this? How many of y'all want to make open litigation and use of force the only exclusions? Okay, so we still have a lot to talk about.
The charges were pending, and certainly that creates some issues, but if the person makes a complaint in the beginning, the clock is ticking. The fact that charges are pending is not going to slow the clock down or whatever the case is. And so even now in our current system, if it's something, a criminal allegation against the officer, then there's no clock. Let's say it's an administrative complaint. We had an officer arrested me, but he cursed me out or something like that. Well, the clock is ticking on that complaint. Now, it may take a month or 2 months before it's resolved at municipal court or whatever the case is. In the meantime, someone is handling that administrative investigation. If that can be mediated, then it needs to occur while the litigation is going on. If there's some legal thing that we can't do that, then that's fine. I would say, though, there would be many cases that would be basically the criteria probably for mediation that we wouldn't be able to do anything with because there will probably be some kind of charge pending. And when you say litigation, whether that's a ticket or a municipal arrest or traffic arrest or whatever it might be.
I'll be honest with you, when people come to me to make a complaint and they have an open charge, I say you need to go talk to your defense attorney because this is all a public record. You can make your complaint after your charges are resolved, right? And at the same time, we've had defense attorneys try to subpoena us about complaints, right? And try to use the fact that their client made a complaint as some sort of evidence against that officer. Right. I would love to avoid all of that, but I hear what you're saying, right? Like, I'm wondering, though, if we can't just say to that person with the open charges, come back after you finish in court.
Well, what if they are then incarcerated? So then it excludes all people that are incarcerated, like say for, how would they then be any way like a participant in the mediation process? Like even if they're doing a sentence of like 5 or 7 years, it might make them, it might do some sort of justice to have them, be able to be and participate in mediation, regardless, because I have lots of clients that will be like, yeah, I'm guilty, but the way that this arrest went down was like, whether they were tased or whether it was like excessive force, whatever it was. But I feel like it might be good for both parties, person that is now incarcerated to have some sort of like, resolution or justice done, even if they're serving their sentence. And for the officer to realize like what happened in that occurrence and then, how it could have gone differently. But if we have, I totally understand and agree with, yes, pending cases should wait till they're done, but then how do people that are incarcerated after those cases are done participate in this process?
Can I come in on one thing? I appreciate it. If you're getting a case from the police department, once they're aware of it, the clock is ticking. Right. So you can't necessarily wait till after it's adjudicated and then tell a person you can come back. I mean, if the officer wants to participate, I guess he or she could, but the administrative case will already be resolved in many cases, one way or the other, so it'll be an after effect. So the benefits of going through mediation will have passed. It wouldn't.
Right.
So
Alvin,
thank you for letting me.
Oh, no, that's fine. My thing's like, there's a code of confidentiality around mediation anyway. So nothing gets in, nothing gets out. If you
I
think
don't know,
about it,
she seems to have some concerns about that.
I have some
don't know.
concerns that somebody's gonna force me to litigate that issue. This is not a matter of law. We're not writing a mediation law that protects mediation, right? We have a policy that does. But that doesn't mean some attorney can't drag us into court and try to get documents.
Well, you mean you're talking about the intake document? Or the mediation? You can't get the mediation.
Is there a law that protects this mediation?
Well, there's a law that protects civil mediation,
Yeah,
there's a law
the
that protects
statutes,
domestic
confidentiality.
mediation, I don't know why it wouldn't protect this.
And maybe we need a legal opinion or something to kind of
Yeah, we
feel
probably need
comfortable
the AG
where
to
we
back
go
us
with
up
this.
on that.
Yeah, actually, that'd be a good.
Maybe from a
If that's the case, that
state
makes me
attorney
feel a
general,
little better.
somebody.
Yes, sir.
There were just two things. I just want to make a distinction, while there are a lot of restorative practices and mediation it can be one of those restorative practices, I think what you're talking about fits more of a restorative justice process, which is different in terms of if you've got someone who's committed a harm and takes responsibility for taking that harm and have doing that harm versus a mediation process where you have two people with equal stature, at least in terms of neither one of them is taking responsibility for what happens, and we're trying to allow for communication so that they understand each other, which is different than I did this, but I still want some kind of healing, some kind of thing to happen.
But that's not, I mean, yes, but that's not
I'm just
exactly-
making
yeah.
that
But that's
distinction.
not exactly also what I'm talking about, like, even if clients that I have that are arrested for something that they may be guilty of, there might be something in the process of their arrest that needs to be addressed to that officer, that usually never is, because then that client's sentenced for 5 years and gets out, and they're trying to get their life back in order,
And
not thinking about
I'm
that,
not
right?
disagreeing, I'm just saying I'd like to be able to think in terms of opening this up to that broader context as we're talking about things, and use some of those practices as well, and especially in the community. The other, I don't know, we talk about what power we have or what power we don't have, but if we're talking about the 60-day issue, and could investigation and mediation go concurrently, and if the mediation isn't successful, then the investigation, then it goes to investigation?
I feel like some city does that. I can't remember which one.
Specific to
Investigate and mediate concurrently.
So in fact, the investigation then becomes closed if in fact the mediation is held and successful, and if it's not, then it just goes into the investigation as scheduled.
I'll write it down as a question. I've not heard of any district doing that, but I've also not asked that specific question before.
I gotta say though, I think that one's sticky, right? Because then part of the incentive for the police department to do this is saving some resources.
Okay,
You know, like, and that would be more resources.
right, got it.
But it's a legitimate question. All right.
Something I also wanted to mention in this process, only complicates things unfortunately, but I do want to mention it, is that at this juncture, I don't know if folks remember what Chief Westbrook had been speaking about at our first meeting, but PIB makes a determination at the outset whether a case should be deemed to be a more serious case in their investigation or a less serious case in their investigation. And the 60-day time period in which one extension can be given is only for the more serious cases, not for the less serious cases. And so maybe this is, I'm only saying this in order to inform people, but my feeling is that oftentimes, at least what other programs have shown to me is that some of the less serious cases are usually the cases that are mediated. And here in New Orleans, the less serious cases are usually the ones which do not have a time clock associated with them.
If they're classified as a DI3.
Right, if the PIB has to determine whether at this juncture, PIB makes a determination whether they think it's more serious, which would be a DI1, or less serious, which would be considered a DI3.
I'm sorry. Process-wise,
Just to clarify that real quick, so what we would be dealing with as far as the complaints then, and I'm just looking at the complaint procedure thing that she gave us, would be the possible findings there are 4: substantiated, unsubstantiated, exonerated, and unfounded. So we would be then dealing with the unsubstantiated, the exonerated, or the unfounded complaints, which look to fall into D2 and 3.
that's actually a little inaccurate. Those are investigative outcomes.
They're investigating.
Right. The DI 1, 2, and 3 are pre-classifications, right? So based on intake in the allegation, they classify the complaint. DI 1 is the serious stuff. DI 2 is internal. DI 3 is least serious. DI 1 has a 60-day time period with a possible extension of an additional 60 days.
I would encourage you to not look at the output at this juncture, because I think it will probably just confuse us.
And by the way, those things are subject to change. I think the consent decree put some new language in there for what the outcomes are going to be. But process-wise, what do y'all think about taking 15 minutes to just flag the stuff so we have a temperature on what we have agreement on? What do y'all think about doing that? Just putting flags down for stuff so we know we can at least determine the stuff that we have agreement on.
I think you need to, maybe it is clear to everyone, but just make sure it's clear to everyone by putting a blue flag on whichever one they choose means what?
We are going to exclude complaints based on, if I put a blue flag by a complainant alleges racial, ethnic, or gender slurs, we will not mediate those complaints.
So it means not.
Right. These are exclusion criteria, so we're putting blue by those that we want to keep as a reason to exclude a complaint. Red by those that we do not think are a good reason to exclude a complaint.
So we're gonna put a tag on each one.
Yes,
That'll be red, blue, or yellow.
yes. And the flags are back here behind me. There. So why don't we take, let's see, it's 3:20 right now. Why don't we add a break to that and come back at 3:30?